Hey everybody, it's Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about how you sell your home if it's in a trust. Before I get to that, I want to remind you, if you have questions about this or anything else related to estate planning or probate, I want you to go ahead and set up a time to talk with me over the phone or in person for free at estatemeeting.com. Super simple. You get to see my calendar. Just pick it. How do we sell a house out of a trust? Well, as with almost everything that you are going to ask me, the answer is it depends. I got asked this question today by a client. They're signing their documents. She's like, "Hey, what if we sell the house?" And I thought, you know what? I get asked that question all the time. So here we go. There are a couple of different scenarios that are going to sort of dictate this. Scenario number one: if you own your home outright, if you don't have any mortgage on it, you don't owe any money on it, what you're probably going to do when you sell your house is just sell it as the trustees of your trust. So when you sign your deed transferring the property over to the buyer, then you would sign it as, Christopher Small, trustee of the amazing estate planning attorney living trust. That's one way. You just sign it over. If you have a mortgage, it doesn't get more complicated. It just depends even more. So when you have a mortgage, right, you have this personal liability on the house for the debt. And when you sell the house, often the mortgage company will want you to do one of two things. Thing number one is they will want you to transfer that house back out of the trust and into your own names personally, and then sign that deed over to whoever's buying the house. The reason they like to do this is because it keeps the title clean. It makes their records very simple and easy to follow, because they can be assured that the person that secured the mortgage in the first place is releasing the mortgage in the second place, and it just makes banks feel all warm and fuzzy inside. Okay, they like to make things difficult. With that being said, doing that process is not that difficult. For me, with my clients, typically I tell them, look, if you're ever going to sell the house and you can't get the title company to create the deed, I'll create the deed for you. It takes 5 seconds. I just reverse the names and it's all good. That's one way. Another way that I've seen happen, actually, is sometimes banks are not all that terrible. And what they will say is, just sign it over as the trustees of the trust. Just give us the trust documents. We'll confirm that, you are you. This is a revocable living trust. It meets all of our guidelines to be able to do this. And then they will just let you sign the deed over as the trustees of the trust. That doesn't happen very often, but I have seen it happen before. That's it. It's pretty simple. So you're either going to sell it in the name of the trust, or you're going to pop it back over into your name and then sell it and sign as you. And then when you get your new property, then you just put that new property into the trust, whether it has a mortgage or not. That's it. So relatively simple, relatively straightforward, but a great question nevertheless. Okay, if you like this video, please hit the like button. If you know someone that needs to hear this, please share it with them. If you have more questions about this or anything else related to estate planning or probate, feel free to reach out to us by going to estatemeeting.com. You can set up a time to talk with us over the phone or in person for free, estatemeeting.com. That's it. Thank you so much for your time. I'm Christopher Small. I'm the owner of CMS Law Firm. I appreciate you. I appreciate your time. And I will be here again to talk to you tomorrow.